going on?
She's currently focusing, so I don't dare talk to her right now. We don't want to break your focus.
No.
I'm on, yeah, it works.
That's all.
Okay, are we ready? I'll call the meeting of the Bennett County Land Use and Information Committee for February 3rd, 2026 to order. Notice has been posted in accordance with Wisconsin statute 19.84 open meetings law. At this point is the time for public comments. If anyone is here to address an issue not on the agenda. Not seeing none, I will move on to a motion to approve the agenda orders.
So move.
Motion by Supervisor Anderson, by Supervisor Bauer, sorry. Motion made and seconded. Any discussion? Hearing none, all in favor?
Aye.
Opposed, none, motion's carried. Approval of the minutes of the January 6th, 2026 meeting.
I make a motion to,
Karen,
motion to approve the minutes from the January 6th meeting.
motion by Karen,
Second.
seconded by Supervisor Blomberg. Any discussion of the minutes? Hearing none, all in favor? Aye. None. Public hearings, we'll open the public hearings portion of the meeting. Jason, do you want to read the public hearing notice?
Notice of public hearing, State of Wisconsin, County of Burnett, Tuesday, February 3rd, 2026 at 9 a.m. at Burnett County Government Center, room 165, Town of Meenan, Severn, Wisconsin, regarding the following. Burnett County Land Use Shoreline Protection Ordinances. Number 1, conditional use permit CUP 2601 Wilderness Fellowship Ministries. Public notice hereby given to all persons in the town of Trade Lake, Burnett County, Wisconsin, that Randy Clawwetter, on behalf of the Wilderness Fellowship Ministries, has made an application for a conditional use permit for the terms of the Burnett County Land Use and Shoreline Protection Code of Ordinances to construct up to 9 additional prayer cabins over the next 3 years, not to exceed a total of 20 prayer cabins located at 21897 Spirit Lake Road West in the RR3 and A2 zoning districts in government lots 1 and 2, section 11, town 37 north, range 18 west. Number 2, map amendment MAP 2603 Kozlowski to rezone the parcel with tax ID 19800 with address 7624 Laverne Road. That part of government lot 6 lying east of the Gandy Dancer Trail, section 5, town 38 north, range 16 west, located in the town of Siren from I-1 industrial to RR3 residential recreation zoning district. Zoning change requested by Nathan Kozlowski.
Okay. So first up is the conditional use permit 2601. So, are you here for that, Randy? Come
Yes,
on,
I sure am.
come forward and just kind of update the committee.
Thank you for the opportunity to come before you today. I think most of you are familiar with the wilderness. We have been in place there for over 53 years. And one of the things that God is doing is touching people through these little conditional use prayer cabins. It seems that way sometimes. these prayer cabins that we have are asking about the conditional use permit for. This is actually not a new conditional use permit. It's actually been in place already. In 21, we were granted for all of the prayer cabins that we had requested was up to 12, because at that point we had already, what's that, 8 or 9 or whatever in place. And so Jason asked me, do you want to put all 12 on there back in 21? I said, yeah, because I don't know what God is going to do. If he's going to provide the funds for all 12, then I want to be able to finish all 12. But the wilderness operates only on donations and operates debt-free. Debt-free. So we don't know when the next prayer cabin is going to be funded. And they're usually funded by individuals who say, I want to do that. So we were able to get a few started on that last conditional use permit, but not the 12. So all this is kind of an extension, is the way I see it, sort of the original permit for the 20. So that's why it's only asking for 9 prayer cabins here. So it seems awkward that we have to go through this permit process for something that's already been done. I just want to make sure that you understand that this has been approved. The neighbors that have been along the lake, I've talked with them and they have been in favor. I believe there have been some letters sent to you from neighbors who are favorable. And so I'm just asking that we be able to extend that conditional use permit, which was already granted. We're just in this 3-year time limit, which doesn't make sense to me, but being that we already have already paid for this permit, I would ask for grace on this committee. Why would we have to pay again for a permit that's already been approved? We have paid that $300. If you guys could find a way to grant that back to us, that would be a blessing, because we are short and tight on finances. And so that would be my request, but that's the situation that I have, that I'm presenting, is we're looking to build the next 9, which would bring us up to the 20 that Jason mentioned. Don't know if that'll happen in 3 years or not, but we trust God and his timing, and he's able to do it.
Any further discussion? Just stay up for a minute. 'Cause
Yeah,
I think
fine.
I agree completely. You know, we did approve this in the past. The reason you have the 3-year expiration is that's typical of conditional use permits. And I think if we can extend them if they haven't expired yet. But once they expire, then being fair to everybody, we go through the same process.
So if I had come to you prior to that expiration date, you could have extended that?
I think we would have had to go through a permitting process probably, but yeah, but it would have still, you wouldn't have been applying, it would just be an extension of the original permit to do that. But
I was not informed of that at all.
well, no, I'm not saying that we would have just approved it. We have a permitting. We have to send notice and do that kind of thing. So we still have to cover that, but it would be, the way I'm trying to explain this is that it's no change, We're not done yet. You want to continue this permit, and, we could have done it that way. But you're quite a ways past the expiration.
That's because we didn't have another cabin funded.
Right, I understand.
And I understood that because it was a 3-year thing, if I would have, when the last cabin was funded, if I would have just extended it, then we would be out of permit right now already, because it's been or 1.5 years more into it. So I'm trying to be frugal
No, I understand.
and not spend more until we actually had somebody that
Right.
said, okay, we
But see,
want to fund it.
But why do we do that in the first place? It's simply, things change over time, like, you're familiar with the Spirit Lake camp, that ultimately got sold and developed.
Oh, Whispering Pines.
Yeah.
Yes.
The Methodist
yes,
camp at Spirit Lake.
Yes.
A friend of mine used to be the manager of that.
Yes.
Anyway, long story short, these permits used to run with the land, and not like a license, but, now the state amended it back in 20,
Sorry.
go ahead.
That's my team's call to prayer. My staff.
Now they can expire, you know,
Yeah.
it can be like a time of sale and type of condition like that.
Yeah.
So there are ways that didn't used to be the case. It used to be.
Yeah, because the first one.
Because the fear would be that if it was sold for some reason, which, you know, we know that camps have been sold and developed. Then all of a sudden, those permits for repair cabins could become, you know, something else. And so the rationale is to try to keep it the way it's supposed to be. And I'm just telling you that for background as to why these procedures are like the way they are. You know, if we could grant this permit for longer than 3 years, but we still probably need to put an expiration on it or some kind of sunset. Simply because,
20 cabins are done.
well,
That would work.
that would be simple, but the other side of it would be that if and not that we ever think Wilderness Fellowship is gonna become privatized and sold, right? We hope not ever, right?
That's right.
But the reality is the world changes, and so we need to be protecting the interest of all the people who were for it, that if something changes, they have recourse, right? Jason, you wanted to?
I don't necessarily believe, based on our guidance from Corporation Council, that you can grant more than 3 years. Because we got that in a legal opinion 6-7 years ago that said you cannot go more than 3 years on a conditional use permit.
Okay, well, I didn't.
And I think that's where this one went to.
I wasn't aware
That
of
is
that.
why this is the procedure we've been operating under, because that's what the attorneys told us to do. So.
Okay, well, good enough. I wasn't aware of that. I either forgot or didn't know about it, one or the other. Go ahead.
Randy had called me and said that back in the day, the committee, Gene Olson and the committee, they had granted the permit for the entire 20 cabins, non-expiring. And so I want to know why it's changed. It's you know, because it's been before 2017 or whatever. Why they're having, you know, I mean, it was already voted on and passed. Why having to go through all this?
Don't know.
I have to ask our county attorney.
Can I clarify one thing? I want to make sure that when Gene Olson was working with us, the prayer cabins were an idea,
Yeah,
but we had no idea how that was going to continue to grow. So to yes and no, up to the 20, I didn't even have vision for 20 cabins at that time. I just thought we might build 1 or 2. But God is really doing some really neat work in people's lives, and we have a marriage retreat, which we just got done with this last weekend, that we cut off at 20 people. So the nice thing would be able to have those 20 couples stay in those cabins that are right there for those marriage retreats. So that's why I came up with this number of 20. Now, if God doesn't want 20, we ain't gonna get 20. That's the way we roll. But I just am having faith that we can push towards that. So I just wanted to clarify that one point. Gene didn't know that we had 20 in mind, neither did I.
okay, because the way I understood it when you
Yeah.
were talking, that you guys had passed, that they had passed 20 cabins. That's the way I was.
No, I ask you to forgive me. I must not have communicated that correctly, and that's what I wanted to clarify.
Misunderstood something or whatever,
But he said yes on the prayer cabins, and he extended that out for 15, 20 years. Just, get it done. That was the attitude. So, thank you.
And the other thing we might want to just kind of bring, when we went through this last one, we had support, it wasn't a period when there have become changes to campgrounds, and there are now camper cabins that are much similar to the prayer cabins, frankly. And we had none of the concern of this becoming a publicly operated campground. We had no reservation whatsoever about approving it the way he wanted to do it, And that was in a point when there was a lot of controversy about that, okay? So the point, I guess, is that we pretty much are obligated to treat every applicant equally. There's not equal protection under the law. We're exposed ways, both for what you get and what you can't do. And so that's also why the process is the way it is. I apologize for being in error about no discretion based on court counsel grant from a few years ago. I don't remember that, but I'm maybe wasn't before my time, but I might not have been at that meeting or something when that happened. But anyway, so Luke, go ahead.
Yeah, well, I grew up in the area of Wilderness Fellowship there, and I know just from the history that great place, no problems, neighbors love the wilderness. But now Jason's trying to do what he feels is right within our ordinances and corporate council, but is there an opportunity, Jason, where we could draft a resolution that meets the criteria here so that you wouldn't be outside of what corporate council says is okay? So let's say that we have a resolution that maybe we bring forward that on a property like this, I mean, obviously, we're concerned about it being privatized at some point. We don't want this conditional use permit to go beyond that, but if we could do something to make it so that it's legit and within our ordinances in zoning to allow for an extended period of time for a conditional use permit, so long as it's not privatized or something, could we draft something like that to put it within your purview?
Well, I think I would have to talk to our county attorney because they were the ones that said it was 3 years based on how our ordinance is written.
So
So
I'm
it
just
would
wondering
be-
how we could modify it so that it does work and it isn't
yeah,
a crazy carve out just for wilderness, but we want to make it legit because I'm really supportive of what they're doing, but I want it to be legit.
I think the thing to do, all would be the concern is it would require an amendment to the ordinance that would have to pass legal scrutiny. I think for today, I think we have no issues with approving him and giving him the 3 years, and then if it's by the time 3 years are up, we will have had an opportunity to look at that, right? So like the next time he comes in, maybe we will have amended the ordinance to provide for such an extension. But I don't think we can do it today.
No, but if we were to go forward, if I made a motion, to approve the conditional use permit and I don't know if it'd be appropriate to reimburse the $300, but then us here in this committee, aside from wilderness being involved, if we could work on an ordinance update so that we
Well, I think,
can.
yeah, let's make that a separate motion.
Okay.
It's not
Yes,
just part of
correct.
this.
Yep.
That just that you'd like us to look into the opportunity, or look into the situation. Now, admittedly, it's really rare, but remember we dealt with the one out on Rooney Lake. That similarly, and they also had to pay the permits and all that for their expansion, and we've done it at Luther Park, Luther Point.
Can we have this
Also-
discussion without having a motion on the floor?
Pardon?
There is not a motion on the floor. Can we have-
No, I'm just kind of back.
We're supposed to-
Yeah, I'm just trying to explain what our processes have been with other similar requests. So no motion yet, but again, I just want, because you guys weren't on the committee yet when that stuff all went on, and I just want to get you up to date.
Yep, sounds good.
So, okay, hearing, is there any further discussion regarding the specific motion that we need to make to?
well, I don't think you've opened the public hearing yet.
No,
Correct.
public,
You
hearing, we haven't had a motion.
I haven't opened it yet, sorry.
No,
There was committee discussion.
this was committee asking the applicant questions.
I got ahead of myself.
Yep.
I had a long ride yesterday and not recovered yet, right? Anyway, okay, so we will now open a public hearing. If there is anyone here to speak to this issue. Nobody here, so I will close the public hearing. And if there's any further discussions, I will, or not, I'll entertain a motion on this matter.
I'd make a motion to approve the conditional use permit with all the recommendations, but also to reimburse the $300. And just due to past problems.
Okay, is there a second?
I'll second it.
A second, motion by Supervisor Tucker to approve the permit, subject to also adding, with all of the recommended staff. Also recommending reimbursement of the fee.
What about the staff recommendations?
I think that's what you said.
Yep, I said you.
I said that, I
All
think.
right,
Question on the reimbursement. Do we have to go through our court counsel to see if that's legal?
Well, I think I think we've got if we get a second on the motion, which we did by Supervisor Moore, then we can discuss the motion. And I'm gonna make the position that we haven't reimbursed any other organizations for their fees. And I don't think that's something we should start to do.
you remember right, when this came up 3 years ago, whichever it was at the boom time of campgrounds. And that was one of the reasons we put the CUP limit to 3 years, was because otherwise we would have had to grant all the other campgrounds unlimited time to put all their things in order. And this was to make sure that things were done appropriately in a timely manner.
Okay, and again, we all agree this is different than that, but it's still, we have to treat applicants similarly for similar processes. So. Any,
We still have to go through the process, we still have to pay for going through it, going through page and going through the paperwork or things, so I'm not in favor of giving this $300 back.
no, those fees pay for the cost of the public hearing. And we're trying to make ourselves not totally dependent on general revenues, so yes, that's true.
And I tend to agree. However, maybe hoping someone that's listening to this maybe would provide and cover that. But I think we get into tricky situations when we're adding, you know, even in the future, and as far as this is concerned, when we're making lots of special exceptions, I think for future committees, we're creating kind of a challenging labyrinth of special conditions. It is challenging. I agree.
Last month, we took a piece out of a CUP, and now we're adding something in. What's gonna happen eventually? To that, worried about a CUP?
Okay, is any, Randy, you have, or Duke, go ahead.
The only reason I suggest reimbursing the $300 is because I just feel from talking to another county board supervisor and to Randy, that if this agreement, I wasn't able to find it in the minutes for one thing, but if we had this agreement that it was not a 3-year thing at the time, that's where my $300 comes from. It's not because of any other, oh, I feel bad for them. I think that maybe we didn't follow through on that, but.
No, I understand your point, but I don't think that's accurate. I think the determination of a 3-year limit based on guidance from council was to prevent let's call it, for lack of a better word, constant turmoil before the committee for various things. And so I think, we failed. We do recognize all personally that this is not the same as that as an operation, but it's so rare. There are so few of them that we never have created a special, type of approval for them. Okay. So in other words, I think we aren't able to do it or ought not to be. So would you mind withdrawing that portion of your motion?
We made a second on it. We're gonna ask what your thoughts are on it. You seconded it, so do you want to vote on it and then go from there?
Okay. Down and come back.
Yeah. Let's just go for a roll call vote on it.
Well, the pros, yeah, we can we can deny it and then ask for a second motion if that you prefer that.
Yeah, I think so.
All right. So hearing the motion, it's to approve the conditional use permit with the county staff recommendations, with a recommendation to desire to refund the application fee, correct?
Yeah.
Are we good with that? Okay. So, but we have a motion and a second, so I'll conduct a roll call vote. Supervisor Tucker,
Yes.
Supervisor Moyer,
Yes.
Supervisor Szymanski. No. Supervisor Blumberg,
No.
Supervisor Chuck Anderson,
No.
Supervisor Karen Locke Anderson.
No.
Supervisor Conray, no. So we denied this motion. Now I'll entertain a motion to approve absent the refund of the fee. Okay, Supervisor Tucker
The
has,
same conditions that we.
with the same exact motion, just simply removing the waiver of the fee,
Second.
seconded by Supervisor Bromberg. Any further discussion? Hearing none, roll call vote. Supervisor Tucker,
Yes.
Supervisor Moyer,
Yes.
Supervisor Szymanski,
Yes.
Supervisor Blomberg,
Yes.
Supervisor Chuck Anderson,
Yes.
Supervisor Karen Lockwell Anderson,
Yes.
Supervisor Connery, yes. Motion's carried. 3 years
There's
again.
other up to 20 in the next 3 years.
We will look into if there is any legal way for us to make it, an extension, but we can't do that today. Good enough?
Very much.
Okay,
Thank you.
so on to our next one, a rezoning request for Kozlowski. So you are, wanna come forward and or is he
He's online, correct, he's
Okay,
online.
sorry, you told me that, so I didn't read it again.
Nathan? Can you unmute yourself?
Are we unable to? If
Oh,
we're,
there he is, you should be on. Are you on?
Hi, can you
Nathan?
guys hear me? Can you hear me?
yes, we're good.
Okay,
So,
awesome.
okay. So
Yeah, I'm
we're-
just, what's
Go
that?
ahead, go ahead and explain what we've got going on here on your behalf.
Yeah, so I'm building a house on my dad's land, and it needs to be rezoned because it's a 35-acre chunk, and it needs to be, I believe it's in industrial right now, and it needs to be rezoned into residential. So I'm not really sure how all that works. I don't know if I need to get it rezoned in order to get the building permit and whatnot, but yeah, I know it needs to be rezoned, so.
Yep, that's accurate and because, again, it's been zoned industrial a long time ago, I'm sure, for
Yeah, yep.
reasons that, today's world, we probably would be really happy to rezone this from industrial to a residential district where you're located.
Yeah. Yep.
So. Okay, I think it's fairly simple, straightforward, so we'll keep you online, but I'll now open the public hearing. Is there anyone here wishing to address this matter at the public hearing? Town of Siren? Yep.
Diane Lund, Siren Township Supervisor. Nathan and his parents came to our township meeting and we discussed their request. And we decided that it was in everybody's best interest to okay the request that he had made.
Yeah, I agree. Looking at the soil conditions and the high water table out there, it's not a good industrial site regardless.
Right.
So, yeah, good enough. Thank you. Anything further? Seeing none, I will close the public hearing and bring it forward to the committee. So, have any discussion about this one? Go ahead, Brent.
No, when we're finished with the discussion, I wanted to make a motion.
Oh, okay. Well, we should at least discuss it a little bit. You know me, so, no, I did look at the soils, and this is Carlsberg and Parida primarily on that property and a little bit high ground, on the far northern end. But it isn't really, I think it was probably industrial for maybe logging or other trucking kind of issues. But I think we have rezoned other similar industrial parcels in the town of Siren in that general vicinity. And they all are kind of have the same issue about you want to be careful what you do there, I think. So I think it's reasonable to everyone's interest to make this rezoning happen, would be my opinion. So.
And for this particular application, it's just recommending a rezone to the county board. So,
Yes.
because it looks like, there was maybe already a dwelling constructed, but that would be a permit issue they would deal with after we rezone.
Yes,
Okay.
yes. Yes, it's a case where, you wouldn't think even it's industrial, but by where it is and what it is, but yeah, it is, so. Okay, are we ready for a motion then?
Sure. I'd like to make a motion to rezone request map 2603 Kozlowski rezoned from I1 to RR3. Including the one staff recommendation, follow all local, county, state and federal requirements for this activity. And then send it on to the county board for county board approval as well.
I'll second it.
Okay, motion by Supervisor Blumberg, seconded by Supervisor Tucker. Any discussion on the motion? Hearing none, roll call vote. Supervisor Tucker.
Yes.
Supervisor Moyer.
Yes.
Supervisor Szymanski.
Yes.
Supervisor Blumberg.
Yes.
Supervisor Chuck Anderson.
Yes.
Supervisor Karen Lonqua Anderson.
Yes,
Supervisor Connery, yes. Motion to recommend approval to the county board is carried. So we're on track.
So Nathan, the final decision will be made at the county board meeting in a few weeks. You don't have to be there. I'll go on your behalf. Usually if they're approved here, they get approved to the county board. So after that happens, and we'll send you a letter saying it was approved.
Okay, awesome. Thank you guys.
Okay, we're good. We're on to land services.
And I'm gonna pass the resolution around if you
Okay.
guys can sign it real quick.
Property information and zoning division reports while we're signing the resolution.
Get that open here real quick. So the reports are in there. These are through the end of the year. Last month's meetings, we were 1 or 2 days short of the end of the year. So these are permit numbers and statistics through the end of December 31st, through the end of 2025. So budget report is in there, so we'll be returning some money back to the general fund. Hasn't finally closed out yet. Highway department always bills stuff out about 2 months after they do. So if we had like an oil change in December, they don't bill it out till like February, so there may be a few little minor, and I don't know if we had an oil change down on the truck or not, but just saying there's still a little lag sometimes out there, so these aren't like the final numbers, but they should be within a few $100 of being correct. Permit numbers are in there, 134 dwellings last year. And then I did at the bottom of those reports, put a little, some graphs in there. Charts for you guys to just look at if you wanted kind of some information about number of permits going back to 2001. Sewer permits and what else did I do? And dwelling permits by year. So just you can kind of see some trends there. Obviously, 2008, was the big housing crash bubble. That's the bottom of everything there. Yeah, other than that, if you have any questions, I guess nothing out of the ordinary in there.
Yeah, it looks. It's interesting in that it seemed like when the bubble popped, we crashed quicker than we did. We trickled down and then we're inching back up towards those almost record high numbers in like 2004. So back then, when I was doing sanitary inspections, I'd make 2 laps, make a lap in the morning, and then the guys were so busy, they're doing a second installation often in the afternoon. Make a second lap around, I think the most inspections I ever did one day was 7, which is, quite a few of them. That was partly because they were on the same properties a couple of times or adjoining, because obviously the contractors had to be working in close proximity to make that happen too. But it was almost unsustainable at that rate, really.
Well, it kind of was, because that's probably why the bubble popped. So
Bubble pop, do the other things, but.
yes, but I
People
mean,
went underwater and, it was
stuff was being
bizarre.
spent too fast.
Actually, that triggered a lot of the recreational rentals for people who bought lake properties because you could, get 20% in 2 or 3 years. When that bubble popped, they were underwater and then they started renting them to try to get some income out of them. But they really didn't buy it because they wanted to be on the lake. They were looking at it as a short-term investment, It was a very weird time to deal with what we were dealing with. So anyway, that's interesting to have that though. And sanitary permits always are tracking to me, the indicator of of building permits more than anything else.
Yeah, and I don't know why in 21 we had that pop there in the sanitary permits, a little spike there in 21, but. Yeah,
So, in any event, yeah, but they last longer and they can be renewed.
correct.
Two things, you can extend them and they are 2-year permit, so. The soil testing similarly, but the soil tests never expire unless the glacier comes by again and rearranges the landscape. So. But future agenda items,
Can we add a discussion with Corp Council about this time limit?
Yeah, so we would want something that would say, CUP timeframe approval.
a provision to extend beyond 6 years under certain circumstances, 3 years, I mean.
Yep.
To certain circumstances, and the main only the benefit of Act 67 was the expiration and time of sale provisions that didn't used to be recommended by state level guidance. Now that we have that, we could do that, but we don't do it very often, but we could.
Reading the ordinance, I see no mention of a 3-year time limit.
Uh,
Googling time limits on conditional use permits for Burnett County, it comes up and says 3 years maximum with 1 extension of 3 years.
and
But
that,
I don't know where that's worded.
that language is coming from the campers.
Campers.
Could be.
But, so the legal guidance we got, it was all because of the Camp Croy on Rooney Lake that this came up. They were asking for a 15-year approval. Their opposition group attorney gave a report or whatever, a opinion, like attorneys do, and said, based on the wording of your ordinance, because it says in there how CUPs are tied to land use permits and weird things like that. And it said that we could only go up to 3 years. And then at that time, Corp Council said, yep, I agree with that legal opinion. That you guys are limited to 3 years based on how it's worded to tied to land use permits in the language.
Right, and
I don't know, that's what,
I think the key thing is it's never been much of an issue except for this one and at Camp Croy probably too, but they're similar in that they're religious organizations as opposed to private businesses.
yeah, they're looking for, because they're not, those are nonprofits, so they're looking long-range planning to help fundraise and all those things, where a
Right.
private business is typically gonna have investors
Yeah, and
that are gonna do it
that,
quick.
that might be what the guidance might want to address is if we're talking about a nonprofit entity,
Yeah,
being careful that we don't define it as we're giving religious organizations privileges.
Right.
We don't give everybody else, but if we do it carefully, we might be able to give ourselves some more discretion, which is always a good thing, right?
But as we were talking also, if the nonprofit were to dissolve, then there may have to be a revisiting of that.
Right, and if we were going to grant an extension, I think we would want to for sure have a time of sale or change of ownership expiration so that we can bring the new owners back into what are they going to actually do, right?
Well, and I guess another question for me would be, does it matter whether or not there's activity? Like if we granted a conditional use permit and they didn't build one prayer cabin, does that make it, is there any difference if they're, they built one year, one next year, you see some. I don't know, it's just two different situations.
So, and part of that is that we have, not so much recently, but historically, we've had conditional use permits that didn't have expirations. I'm talking in the 80s and 90s. I give you the variances similarly, and a perfect example of that didn't happen in Burnett County, but in Washburn County on County E, where you go by Big Bass Lake as you leave Big McKenzie going towards Spooner. A guy got a variance to build a house, much reduced setback to the lake because he was squeezed between E and the lake. No sunset on it, right? The county relocated E about 200 feet further back. And the guy hurriedly came in as they staked it out, to relocate the highway to get his permit to build the house. And I, of course, issued it. But I told him, you wouldn't have had to, there was no sunset on this. This was a forever approval. But there again, there was no longer a hardship when they moved the county highway 200 feet away, right? And so, it sounds bizarre, but for those kinds of things is why you need to have some expiration issue.
One up in, West Township, was a mobile home on the kind of overlooking the river, which you have to build something within 3 years, even if it's only pouring the footing in, you have to make some effort to show that you're working on it.
Yeah, I remember that one too, similar, but I mean, that's just sort of the why, these things come up and then you're. And that was, I can kind of remember the Department of Justice guidance that the county's administrators organization requested. I mean, a county had requested it from the legal opinion, Attorney General's opinion about that. And that subsequently guidance came out that, yeah, you can put sunsets on things because things do change. Go ahead.
Well, I really appreciate Jason looking into that and keeping us on the straight and narrow, but to kind of, I think being related to what Supervisor Blomberg said, and Supervisor Szymanski said, I think we want the ability to extend the conditional use permit, but it's gotta be, to me, it's gotta be based on, it's not privatized or the ownership or the purpose of the property has changed or something like that. So if we could have an ordinance that comes through or a resolution that changed that to kind of stay within those bounds, so it's not where we vote for a conditional use permit, it changes hands and all of a sudden we got a huge mess on our hands. We can't have that either.
No,
So,
go ahead, Karen.
I'm wondering if there's a way to simplify it. It's like, could we ask corporate counsel? I just don't want to muddy our ordinances where if this, if that, if this, if that. I just think it makes it more confusing, anyone trying to find anything. And whatever those ordinances are tied to, did they get changed to reflect whatever? It's like, could we write somewhere, in the instance of a blah, 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 we have the discretion to waive a
Well, I'm thinking,
fee. I mean, because I think that was more the problem was.
and retract it.
well, I'm thinking we would probably come up with a section just like in the CUP section that would say for a CUP in this scenario, the committee has discretion to extend it or do something like that. I think we would, instead of trying to tie it in a whole bunch of different places, I guess I'd like to have it in the CUP section and just have it
Just in the
in some
generic-
little paragraph.
But it's not a rush. Let's just put that on for discussion, put it on the agenda to see where we're going with it. And at some point, we have to go through the amendment process to change the ordinance. But that's relatively, be nice to do a couple other little cleanups if we're at it, but we'll see. Okay.
Good.
Then next meeting date, we need to talk about that a little bit because we don't have any public hearing scheduled. Nobody wanted to do anything in March.
Good, because I won't be here.
So the point, it is just simply that we, if we don't have any business to do, we'll probably just cancel the meeting.
Do we have anything that is a pressing issue that we
So
should be?
that's the question. Yeah, that's why I wanted to talk about it. So,
What keeps cropping up for me is when I look at the number of variances, I'm concerned, I do think they need the flexibility to, and we don't have control over what they do. And kind of an entity of their own. But I see a lot of variances being granted that basically, to me, infringe on our shoreline protection things, and I don't know. I just feel like is it a discussion we can have? Can we offer guidance? Can we basically offer guidance to Jason saying, okay, they might do that, but we don't want you participating in things that go against shoreline protection. I'm just, in attending these meetings too, I'm concerned.
In a sense, when the reason it's going to a variance anyway is Jason's already said, no, you can't do that.
Yeah, that's the point of a variance is I can't approve a permit.
Right. At the meetings I've been to, they haven't even, 95% of the time, they're not even discussing the 3-step variance. And I would like to have that be their duty because it's part of their responsibility. Yet I feel like we're taking on that responsibility of figuring out what the 3 steps.
It's a complicated world we live in now because it used to be that if a board was not following that process, DNR had the authority to appeal their decision, but they don't do that anymore. So if it's gonna be any kind of a governmental body that would challenge them, it would maybe be us, but it seems, but two entities of the county here, right?
Like, I feel like we are, held accountable by the main board. Who holds them accountable?
The court
The
system.
chairman?
Well, they're a quasi judicial
Judicial
body.
Yeah.
So just like you guys don't control what the judge does, quasi judicial body is kind of their own
See,
entity.
the point of the whole thing was that a quasi judicial body to provide relief when unique conditions created hardship, right? But the question we're getting now is that my little home's not big enough and I need it to be a starter castle, and that's a hardship. And if the board thinks that's true, that's kind of setting aside the three-step process to demonstrate hardship that Karen mentioned. So it's sort of like at the same time, the shoreline zoning rules changed to allow a lot of stuff that used to only be allowed by variance, if at all. The theory was that would reduce the need for variances, but instead it's, to my mind, almost had a counterintuitive effect that, well, you can do all this stuff, so how come I can't do that? Which, is not from let's call it untrained eye, it looks to be the same thing. But, in fact isn't. Go ahead.
So Jason, when it comes to shoreline protection, does our zoning have, I guess what we'll call stiffer requirements than what the state statutes allow for, or?
Well, our model ordinance, it was approved by the DNR when we revised it.
Ours is, but do we go
Yeah.
beyond what the state itself by statute requires? I mean, are we protect our shorelines more than what the state requires us to, is what I'm asking.
I would
Have an
say
example?
not really.
I'm just kind of, when we have all these variances coming through, it just makes me wonder if we don't want so many variances coming through, or do we have stiffer requirements that we used to have, or that?
Oh,
I mean,
if you look at most of the variances, there are patios down by the lake, that's not allowed.
No,
Yeah,
I'd
state
say
statute.
we're not, the state actually, I'm gonna do the old curmudgeon told stories for you again, like happened. But I've met with DNR staff a long time ago with another zoning administrator and a county code administrator's issue about that. And at that time, they said that the NR 115 is a minimum standard and counties can be stricter. And we went through a process where we created bigger setbacks and whatnot, all through the northern counties, not just us.
Is that where
And-
the 1,000-foot zoning and 300-foot zoning comes into play for the townships that
No.
don't use county zoning?
No, that's
Well, that's
state
under-
law,
Yeah, that's under shoreline
That's what I'm
zoning.
saying.
Yeah.
That's a state thing.
state
Yes.
law,
So
right, the
that,
shoreline
even though
zone.
those townships don't, take
The
on county
state-
zoning.
The state mandates that
Yeah.
we have to do shoreline zoning everywhere.
That's what I'm getting. That's
Right,
what I'm getting at.
and if a
Okay.
township wishes to do that, they can adopt their own. Town of Spider Lake in Sawyer County has its own zoning and required 200-foot lots in the 70s.
And they have to have their own Jason too.
They don't
So-
go, they don't just replace the county, they just go in conjunction with the county. That's the most they can do. But back to what I was getting at, then they amended NR 115, they basically said that the state is exactly the same from Webster to Waukesha, and 75 feet is 75 feet, and you can't be more. So we're not stricter than the state in those regards at all.
Yeah, I mean, we're following the 75-foot setback. We used to have 100-foot setbacks on class 3.
Mhm.
And that was considered more restrictive, so we took that out. So now we're 75-foot on
And that
everything.
was all approved by DNR back
Yep.
when we did it, because they, at that time, their stance was that their standards were minimum and counties wishing to be more protective could be. But that went away again in the amendment package a few years ago.
Well, sometimes I look and I say, well, we got the village of Webster and Grantsburg and Siren and Danbury and so on and so forth, which don't fall under county zoning.
Danbury does.
Well, Danbury, because they're not
Incorporated.
right. And then we have townships that are not under county zoning. So when you look at our whole zoning operations, it's not a real big part of the population that it actually zones. So it's just, to me, it's kind of crazy. We got such a, we have roughly 18,000 people, but the majority of them are not under county zoning.
I'll use my town for example. Jackson was unzoned until, 2005 about?
4 or 5 or
Yeah.
8, somewhere in that range,
I
yeah.
looked up the shorelands map. There was hardly any of Jackson that wasn't zoned. You know, and as far as where people lived, the vast majority in Jackson were under zoning because they live in the shorelands. So towns said, yeah, why are we not zoned? And they adopted zoning. Happened quite a bit, you know, quite a few towns adopted zoning in order to be zoned because of threats of, you know, campgrounds and gravel pits and other things that they were not in favor of having happen to them. So when I started in Washburn County, I had 19 out of 21 zone townships, okay? Jim Flanagan started here a year before me. He had 7 out of 21 zone townships. Now we're about the same as Washburn.
You add up the village of Grantsburg, Siren and Webster, that's probably about 4,000. And there's 17,000
Townships.
in the county, so shoreline zoning. And most of the people. I mean, we could do some analysis on how many people are actually within 1,000 feet and 300 feet for population wise versus those that are out. I mean, so I don't, but if you look like in, the town of Jackson, the town of Scott, town of Webb Lake, most people are living within the 300.
So they're zoned per state statute.
Correct.
Zoned that way.
Yes.
I guess my concern is I see more and more that are circumventing that zoning. And, you know, sometimes there might be good reasons, but at the meetings, the majority of the time, they're not following the mandated process.
Right, that's back to Karen's original question. We got been off on its lark, didn't we?
Right, and that being said, I think it's also being used as a means to permit after the fact. And is that fair to people who go through the process? People forget, people do things, but I think we can have fewer ordinances or deal with them less if we mean the ones that we have. I mean, but if there's a process and there seems to be whereby people just don't have to follow the rules, it's easier not to, then why wouldn't they take the path of least resistance? And I would just like to have it swing back to some sort of expected conformance.
I think a perfectly good example of that is today, Randy could have not shown up here, could have built 9 more prayer cabins.
Yeah.
Come in and after the fact and said, oh, I'm sorry, I forgot my conditional use permit expired. And they would have rubber stamped it and said, oh, they're prayer cabins, you know, no big deal. And so I feel like I'm frustrated that we try to hold up the rules and regulations and they're just going, wow, I feel so sorry for that guy.
Well,
But who talks to them?
That's what I would-
Hey, you gotta
But I
start.
would suggest, but I wouldn't want to do it in an open session. Is I would suggest because it would be a matter of possible litigation. If you want to talk about taking some kind of action, I think it would need to be a consultation with corp counsel in a closed session.
Or
Makes
we
sense?
may have more zoning than what people want too. There may be more protection in place than what people actually want too. I don't know. I haven't talked to people.
Well, as far as the shoreline stuff goes, that's pretty much within the state NR 115 and the county ordinance adopted under that.
I'm just saying that maybe individuals that are applying for these variances really don't like our county ordinance. I don't know. I haven't
But
talked.
it's state, I'm talking, I mean, when I'm looking at this, I'm addressing, I mean, not that there may or may not be other issues, but I'm primarily addressing the shoreland stuff. I mean, that's a state thing
If
that
you-
we seem to be.
Beyond it is what they're saying.
If you look at, if you just kind of scroll through the variance list, it tells you what the variance was for. And a lot of them are lake setback, lake setback, lake setback. That's state law. That's not us being any more restrictive. Cause that's 75-foot setback, and then that's what you can do when you're between 35 and 75. You can only expand certain amounts. That's everything within 75 feet. That is state law that these people are trying to get rid
So
of.
we're allowed to make a variance against state law then?
Yeah.
Jeez. Okay.
That's what the variance process is for.
You might say that it's being used inappropriately, you know, and again, and this gets into, you know, why if DNR is restricted from appealing these things, that, you know, back in the days, remember Duke, when there was such a thing as a public intervener, who was an attorney that was hired to have a separate office to sue DNR when he didn't hold up their end, right? All of that stuff kind of went away, and part of the justification was every citizen of the state has the capacity of being a public intervener in these matters. It would take citizens to do that. The guy who's the president of the North Sand Lake Association was like on the verge of doing that on a variance that got approved on North Sand, but didn't, you know, but he was upset about it, called me, and we talked about it, and I kind of explained the same thing to him, you know, and then another one came along and I sent it to him to look at, you know, the notice, because we don't notice the lake, literally, everybody on it, on a variance, it would get really burdensome, right? But he looked at that one and said, well, you know, that one probably isn't too bad, and got approved, but it sort of was a reasonable one, where a small expansion to the rear to fill in an area or something that I don't remember it precisely, but so, you know, there are some that are fine. That's kind of the trouble, though, is they each one is supposed to be unique and not precedent for anything else, but you can fall into well, it's kind of like the last one we did, and, you know, build up a mindset of approving more than you deny. And frankly, back in the day, Burnett County's Board of Adjustment hardly ever approved anything once, like about when Jason started, right?
And-
We're pretty hard to get a variance approved. Now it seems to be the opposite.
Who appoints people to the board?
County board through the chair.
Donnie.
So the county board votes on people that want to be on the.
No, they give, I guess we vote their approval.
Yeah, because I think Wanda has it on the calendar every July to reappoint certain members, because their terms expire, like
It's staggered.
staggered.
Staggered, so they're not all at once. And the other thing was, it used to be, this I might be confused about for a second, but the boards used to be 5, and they were reduced to 3. And I think we put it back to 5 then, hoping that it would be a little more diverse, but it hasn't been.
And we don't have a say for good reason. I mean, because otherwise people don't have a true variance, true variance pathway.
The legislature doesn't get to pick the Supreme Court, right?
But to any extent that we are participating, you know, but it's also expensive if we choose to appeal something, because their attorney is our corporate counsel until we need them. So then we would be using our corporate counsel, then we would have to, then the county would also have to pay for the Board of Adjustment too. I mean, so if we decided to, I'm just wondering if there's a different way to provide guidance, or to maybe have our department not participate in something that seems to, you know, and a lot of it to me is the 3-step process, you know, when I'm at a meeting and they seem to be not discussing or doing that, because to me, that's what says to me and the public that it's like, we've checked this box, this box, this box, and therefore, you know, this is a reasonable time to grant a variance, but I'm not seeing that happen.
But the other thing about the board too is it needs to be diverse. It can't be like everybody from one township. You know, they're scattered, and you want to have,
You can't be from a village or city.
no, because
You have to be,
Or any place that's unzoned. I don't think they
No.
can have one, can they?
yeah, that doesn't matter.
Or just, oh, that's.
they just have to be from different municipalities. They
Right.
can't be 2 from the
And
same
not from
township.
an incorporated municipality, because it's a different governmental jurisdiction.
There
But-
can't be
and-
2 from the
And
township.
actually, you kind of like people who are knowledgeable about building and, you know, land, have a background of assessing these things. I mean, you know, I think the membership of the board is probably pretty good. It just seems to be overly generous in granting things.
Well, and you know, it's tough to tell someone no.
Yes. Does the Board of Adjustment generally go out and make site visits? at
They
these
do a
places?
site visit on everyone, yeah,
Okay, good.
yeah.
Me, you're on that, aren't you? You're on?
We can't be.
Can't be on it if you're on this.
So you said you're on.
No, I go to the meetings. But we,
Interesting. I might have to go to a couple of those.
Oh, they're online too,
they start again in April or May.
April.
Well, but let's do with this for now, is let's let this sit for now, but maybe we should contemplate discussing what role we should play with our council, just to see, that wouldn't be a bad idea. I don't think, but anyway, for as far as next month's go, if we don't do that, is there any other reasons we need to meet? We can call a meeting, within a week, it just would be a business meeting. Wouldn't be any public hearings.
Well, we can always move the Board of Adjustment thing to April, May.
Well, right.
We don't need to have a meeting just for that.
Not just for that, but I
Yeah.
don't wanna see it get lost.
Well, I agree. I totally agree with you.
Is there any kind of an ordinance or whatever that says we have to have so many meetings a year?
We've typically cancel kind of about one a year, I think, is kind of our kind of typical.
Remember, nobody applied to CUP or rezoning. Public hearings really drive our agenda more than anything. So if we don't have one, we save the county a little money by not meeting. But that's about it.
And I guess that was my point. I don't want the county to have to pay for something where we don't need to meet. Let's save the county some money. However, if we're diving into something that's gonna be really time consuming.
Let's just kind of ask Jason to look into this
Okay.
discussion and see what
Yeah.
Stephanie thinks and, get back to us.
Okay.
Does that make sense?
Yeah.
Okay. So now we can entertain a motion to adjourn.
I make a motion to adjourn.
Okay, motion by Lee, second by Chuck. Further discussion? None, motions to adjourn? All in favor? Aye, we're adjourned.
Yep.
Well, good, how are you?